Sheldon Underwood.
Nicole Hughes on behalf of the people.
Andrew Banis, Assistant Public Defender. With and on behalf of Mr. Underwood. Mr. Underwood, please state your name for the court.
Sheldon Underwood.
And right away, we are stepping into a bond hearing where the stakes are already serious. Sheldon Underwood is in front of Judge Simpson, and this is not just a quick scheduling moment. The defense is trying to slow things down, asking for time to hire private counsel, while also preparing to argue for a lower bond so Underwood can get back to work and keep paying child support. Sounds reasonable on the surface, right? But courtroom stories almost never stay that simple, because once the prosecution starts explaining why that bond was set so high, this hearing takes a sharp turn from routine procedure into a full-blown public safety argument. Judge Simpson is listening carefully, but you can already feel the tension building. This is the kind of hearing where one detail can completely change the direction of the case.
What are we doing?
Your Honor, Mr. Underwood has two requests. One pertains to bond, but the first request is for a 1-week adjournment to hire private counsel. He informs me that his family has already reached out and is in contact with one of the local law firms.
Are they going to be able to accomplish that in a week?
I did discuss that with him, and he believes so.
All right. I'm only going to adjourn it. Well, I'm going to adjourn it to the 21st, if that's what he's doing, because he's only going to get one adjournment to get counsel. So probable cause conference, September 21st, 2023, 9 a.m. Or his Zoom invite indicates yes, ask the bond.
Thank you. Mr. Underwood is currently held on a $200,000 bond on this case, no other cases. He is requesting a reduction to a 10%. That's still quite significant. I understand the charges are serious in terms of the fleeing, and there's also a third count relating to the vehicle. His main concern is to get back to work if that $20,000 bond could even be posted and continue making his child support payments.
Response?
Your Honor, please let me know when you're convinced and tell me to stop talking because I could go on for days about this one. First, the defendant does have another, he does have another case. He has a friend of the court bench warrant right now. So in terms of him wanting to continue to pay his child support, he's got a bench warrant for his arrest for failure to support.
That single line instantly changes the entire defense argument. The defense just told the court that Underwood wants a bond reduction so he can continue making child support payments. But the prosecutor immediately fires back with the contradiction. There is already a friend of the court bench warrant connected to failure to support. That is a brutal response because it attacks the emotional foundation of the request. In bond hearings, credibility matters. If the reason for release is, I need to support my child, but the court is hearing there is already a warrant tied to unpaid support, that becomes a major problem. And this is where prosecutors are dangerous in bond arguments. They do not just say no, they reframe the entire request as unreliable. For viewers, here is the question. Should a judge consider a defendant's stated responsibilities if the record shows they have already failed to meet them?
Right now, the bench warrant has a bond of $536 for past due payments. The defendant's bond is set in the amount of $200,000. I charged this case. I requested $250,000, and I am renewing that request at this time. The defendant took multiple interstate police agencies on a high-speed chase beginning in Toledo, Ohio. He fled from Toledo all the way up to Ann Arbor. The third charge that Mr. Banis mentioned, the thing that involved the vehicle, that was when the defendant drove his car directly into a Pittsfield Township occupied patrol car, which is an FA on a police officer. The defendant was fleeing from Ohio with an Ohio State helicopter following him into Ohio. Pittsfield, the Washtenaw County Sheriff's Office, as well as Ann Arbor had to get involved in this chase. He was doing speeds as fast as 114 miles per hour on Michigan Avenue. He wasn't, not that that's even part of a speed limit, but he wasn't even on a highway when he was doing 114 miles per hour. In terms of him being a danger to society, his reckless fleeing and his intentional assault on a police officer while fleeing certainly demonstrates that he's a danger to society. And then, of course, he's a flight risk, given that he took multiple jurisdictions on an interstate police chase. He ditched his car on US 23, tried to get out and run. When the police found him, thankfully, he was compliant and didn't continue to assault them. And they were able to take him into custody at that time. When they searched his vehicle, they did not recover a firearm, but they did recover a magazine that was empty, did not have any ammunition in it. Again, the people are requesting at this time that his bond be increased to the initial request of $250,000.
By this point, the prosecution has completely flipped the hearing. The defense came in asking to reduce a $200,000 bond to 10%, meaning the defendant could potentially post $20,000. But the prosecutor is not only opposing that reduction, she is asking Judge Simpson to raise the bond to $250,000. And the facts she lays out are intense. A high-speed interstate chase, multiple agencies involved, speeds allegedly reaching 114 miles per hour, and a patrol car being struck hard enough that it could no longer continue pursuit. In a bond hearing, the judge is looking at risk. Danger to the public, danger to officers, and risk of flight. The prosecution hits all three. The empty magazine found in the vehicle adds another concerning detail, even without a firearm recovered. This is no longer a simple let him work argument. This is now about whether the community is safe if he gets out.
When he rammed the Pittsfield officers, were any of the officers injured?
Thank goodness they were not. The officer was not injured. His car was damaged to the extent that he was unable to continue to pursue the defendant, though.
May I make two very brief minor points?
Go for it.
First, at least according to ex-jail, I think the front of the court warrant has been resolved, but Ms. Hughes might have some information that I'm not aware of. As I read the police report, and this is no doubt a factual dispute, but as I read the officer's statement, and I'm not blaming the officer in any way, but as I read that statement, the officer hit the defendant's car. Now, how that happened, but that's how I read it. And I'm not
Does
saying
that help you? They're on a high-speed chase from Ohio. So the officer hits his vehicle, maybe to stop it and save other people. I'll let you go on. Go ahead.
No, that's it, Your Honor. Thank you.
Motion for bond reduction is denied. I will, and quite frankly, given the circumstances as laid out by the people, I think the $200,000 bond is set very low. I don't even think that the $250,000 bond is appropriate, because from Ohio to Ann Arbor, all of the individuals that would have been on that roadway, as well as once he got himself on Michigan Avenue doing those high speeds, he put all of those people in danger. He put all of the officers that had to pursue him in danger. And for no reason. And at any given point in time, given those speeds, somebody who could have been just out could have been killed. Court will set bond in the amount of $500,000 cash surety.
Thank you, Your Honor.
Judge Simpson's reaction is firm, and this is where the hearing becomes a warning shot. He is not just rejecting the defense request, he is explaining why the original bond may have been too low. The judge focuses on the danger created for ordinary people on the road, officers in pursuit, and anyone who could have been caught in the middle of that chase. That phrase, "for no reason," matters. It strips away excuses. From the court's perspective, this was not a mistake in paperwork or a misunderstanding. This was conduct that allegedly put lives at risk. And then the ruling lands. Bond goes up to $500,000 cash surety. That is double what the prosecutor requested. When a judge goes higher than even the prosecution's renewed request, that tells you exactly how seriously the court viewed the facts.
Versus Alante Lovely.
Allie Zend on behalf of the people. First Assistant Public Defender Kalina Anderson with it on behalf of Ms. Lovely. Ms. Lovely, can you state your name, please?
Yes, good morning. Alante Lovely.
And Your Honor, in this matter, we're requesting a preliminary exam, and at the appropriate time, may I address our bond, please?
Yes, I don't think I've addressed this yet. You did see there. Did we address the social media post yet?
No, Your Honor,
Yes.
those were posted. There were other posts after we addressed it the last hearing.
No, you got to be kidding me.
There were two posts. One that was my stalker is playing victim. Good thing I'm a survivor. And another post that said stalker is on the move on July 28th, which was after the hearing on the 27th. And then the GoFundMe was also never taken down.
You want this set for a preliminary examination, is that correct, Ms. Anderson?
Your Honor, I was asking for a preliminary exam. I had spoken with Ms. Kirby with regards to violations and was told that there were no bond violations in relation to social media. So I just asked to confirm if that was before or after these additional ones that were just read off.
They were after, and I put you on the email when I submitted the motions, and I don't have an email where I said there were no violations. There were violations, which is the reason why there was no offer, which is what I said in my email.
Okay, I'll have to double check that. I had something different in my notes. So yes, Your Honor, we are asking for an exam. I'd ask that any bond violations be set over with that, so I have an opportunity to speak with Ms. Lovely.
Now the hearing shifts into a second case, and the energy changes, but the tension does not disappear. Alante Lovely is before Judge Simpson, and the issue starts with a preliminary examination request. But almost immediately, the court circles back to social media posts, and that is where everything starts unraveling. The prosecution says there were new posts after the last hearing, including language about a stalker and victimhood, plus a GoFundMe that allegedly had not been removed. That matters because courts take bond conditions seriously, especially when they involve contact, intimidation, harassment, or public commentary connected to a case. Even if someone believes their posts are vague, the judge may view them through the lens of prior warnings. What do you think? If a judge clearly warns someone about posting, should vague posts still count as a violation if they appear connected to the case?
Well, that's going to be a problem because I'll just tell you this. I'll set preliminary examination August 29th, 2023, 9 a.m. That is before me. And I'm were the previous postings removed?
I believe everything else was removed except for the GoFundMe, but then she posted after the hearing on the 28th, the new posts.
I don't believe this. Here's my problem, Miss Anderson, is the last hearing, what may have been inappropriate post and other things, I allowed this defendant to remain out, admonished her, told her exactly what to do. And now I'm looking here and just must think I'm playing. And that I don't mean what I say. I don't know. Your client wants to say something. If she wants to say something, you know what? I'll give you a breakout room to talk to her
Okay.
before I do what I'm going to do. But I'll hear from her. So put them into a breakout room, quarter past the matter. Michigan versus Alante Lovely.
Allie Zend on behalf of the
First Assistant Public Defender Kalina Anderson with it on behalf of Ms. Lovely.
All right. So I've set the exam. Now, where are we with regard to this bond issue?
This is a classic courtroom pressure moment. Judge Simpson already paused the matter and gave the defense time to speak privately with Lovely. That is important because it shows the judge did not immediately jump to a ruling without allowing counsel to talk to the client. But when they return, the central question remains: what happens with bond now? The defense argues that the posts do not specifically name anyone connected to the case, that Lovely has taken things down, and that she understands she should not post about the matter. They also raise a human detail. She has visitation with her son coming up. That is an emotional factor, but bond decisions are not only emotional. The court has to decide whether instructions were followed and whether future compliance is likely. At this point, Judge Simpson is not just weighing posts, he is weighing trust.
Your Honor, I had a chance to speak with Miss Lovely, and she indicates to me that the postings don't have anything to do with this case. I had a chance to review the motion as well as the documents that were attached. I don't see anything specific that's naming any particular person involved in this case. She's also indicated to me that she has taken everything down. We had a detailed discussion about not posting about this case and not posting at all, and the potential for deactivating the account in its entirety while this matter is pending. She is concerned as she's scheduled to have some visitation with her son next week. She's hopeful that Your Honor will give her another chance with regards to this, especially now that she's taken everything down. Other than that, Your Honor, we don't have anything additional to add.
Is the child's name Alan?
That's his middle name, Your Honor.
So explain to me this Love and Company LLC thing.
The Love and Company LLC is just my company, my production company. What was shown to me was my profile link called Tap Link, which goes from my social media to this various profile. However, the same day that I got from judgment from the last court, I took that down and updated that document to my public defender so she know exactly what it looks like now. And it doesn't look like that anymore. I've taken everything down, removed all the links that I had associated with any shares or comments or any posts that may or may not have been related. And that's been since she told me to do that.
What case is that first post related to?
Now Judge Simpson asks the question that cuts straight through the defense explanation. If Lovely says the post was not about this case, the judge wants specifics. What case was it about? That is a very practical courtroom move. Judges hear explanations all the time, but when an explanation depends on another dispute, another case, or another context, the court can ask for proof. Lovely says it relates to a landlord situation and an eviction matter, but Judge Simpson wants a case number. That is not a random demand. A case number would let the court verify whether the explanation is real, current, and connected to the post. Without that, the judge is left with a claim that may sound convenient. This is where courtroom credibility becomes everything. The more vague the answer sounds, the more suspicious it becomes under pressure.
Give me a case number. Says it's related to something else. Give me a case number so I can look
Your
it up.
Honor, it's not
I
a
don't believe
case.
that for one. I don't believe it for 1 minute.
Your Honor, that as I discussed with my public defender, I have been going through a different matter with my landlord.
Give me a case number.
That situation was an eviction case, and that the moments that I had with the bullying, harassment, and stalking from my landlord was a situation that was referenced.
Give me a case number.
I can give you the eviction case number associated with my apartment and the letter that stated that she's no longer around because of the situation. That's the only thing I can give you at this time. There's other things that's going on. I'm dealing with various things, but that was an old post that has been taken down that had nothing to do with this case and nothing to do with that case now either. Everything has been taken care of.
Anything else from the people?
No, Your Honor, just that I believe when the victim reached out to us, he said those were posted on July 28th from the screenshots. So I'm not sure exactly what those would be, but that was the date that we were given. But that's all from the people.
So, ma'am, when were these posted?
They're not since deleted. I don't know the exact date, but it was when I got the notice from on my door from the landlord that stated again.
When was that?
That was July.
This is the moment where the timeline starts hurting the defense. The judge is trying to pin down when the posts were made because timing is everything. If the posts happened after the prior court warning, then the issue becomes much more serious. Lovely says it was July and near the end of July, but she does not give a clean exact date. The prosecutor says the screenshots were dated July 28th, which was after the hearing on July 27th. That one-day difference is massive. A post before the warning is one thing. A post after a direct courtroom warning is something else entirely. Judge Simpson is clearly not buying the explanation, and you can hear the frustration building. Should a judge give more time to verify dates, or is the screenshot date enough to act immediately when a prior order was already given?
It had to be near the end of July. There's a lot of things that are circling around this matter. So correlation, can I say it was right after that date? No, because I was in the process.
I'm not believing any of this.
I'm sorry to hear that.
So, well, you may be. Ms. Anderson, anything else you want to say?
Your Honor, I would ask if you would consider giving us some additional time if we can substantiate any of the eviction information or when that letter was presented to my client to try to pin down those dates for the
Well,
court.
she's going to have about 5 hours to get it to you. I'll set a hearing on it, but right now, I gave very specific instructions on July 27th, what she was supposed to do. I expect my instructions to be followed. I don't expect this to come up at all. And if you want to play fast and loose with the court's orders or how you think about how the court's orders are or what you're going to say regarding it, well, you can do that if you want, but you better be ready to go if you're going to come up against me on my orders. Defendant's bond is hereby revoked. Defendant is to report to the Washtenaw County Jail by 6 p.m. this evening. Her failure to do so will result in a bench warrant being issued. I will set a bond hearing on this.
Bond hearings next week at 3 o'clock, 20 minutes at 3 p.m.
I'll set a bond hearing on this for, that's 24.
Yes, sir.
Bond hearing on August 24th, 2023 at what time?
3 p.m.
At 3 p.m. in person. So, ma'am, I'm just going to give you a fair warning. If you think I'm not, you didn't think I was serious about my last order. If you think I'm not serious about this order, you're going to find yourself very wrong. Because if you're not in that jail by 6 p.m. this evening, I will send somebody to get you.
I understand,
you.
Your Honor. I'm sorry that you feel that way. And I hope we can resolve this
You
matter.
better be quiet because she's about to pick up a whole lot more, Miss Anderson.
And I'm sorry, Your Honor, I didn't get the exam date.
The exam date is on the 29th. Bond hearing I'm setting for the 24th at 3 o'clock.
Thank you, Your Honor.
And that final response almost makes things worse. Judge Simpson has already revoked Lovely's bond, ordered her to report to the Washtenaw County Jail by 6:00 p.m., and warned that failure to appear will result in a bench warrant, with someone being sent to get her if necessary. The ruling is clear. The court believes its prior instructions were not followed, and Judge Simpson is making it unmistakable that bond conditions are not suggestions. The key takeaway from both hearings is simple. Bond is about trust, public safety, and compliance. Underwood's bond was not reduced. It was increased to $500,000 cash surety after the court heard details of the alleged chase and danger to the public. Lovely's bond was revoked after the court found the social media issue serious enough to require jail reporting that same evening. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.